Thank you for coming. My name's Naomi Stallard. I work with at the Department of Training and Workforce Development. I look after intellectual property and copyright, the program officer there. Can I just get a little show of hands as to where people work today? How many people do we have from state training providers here? Here? And RTOs, private, a lot of RTOs. Any schools here? Oh, great. Okay, excellent. I'll just begin with our disclaimer and copyright notice. Of course, a copyright presentation can't be complete without a copyright notice. Just letting you know that this is basically not legal advice. This is just support and information for you. It's for your guidance, and if you do need legal advice, I'd recommend going and speaking to a lawyer. Also letting you know that we've actually made this presentation available. When it is available on our, we'll put it up on the in a PDF on our website, just letting you know that it is actually licensed under a Creative Commons licence, so you'll be able to reuse that, but it's a non-commercial licence. Just letting you also know that some of the material in this presentation is not available through that licence, and that would include our logo, so no ripping off of the department logo, which I'm sure you're all going to do, and also some of the third-party images are available through different licences which have all been attributed, and so please don't take those off without asking permission to those relevant people. Okay, this is just the outline. I'll let you read that. We'll be looking at a whole range of issues, and there's so much to talk about with copyright in the digital world, and it keeps changing, but we'll touch on some of the main issues that tend to crop up in a classroom and training situation. Okay, we'll go back to basics and just really briefly cover, just so that we all know where we're at, some of the basics of copyright, just a very brief overview. How many of you have attended other copyright sessions here, just to get a show of hands? Okay. Well, copyright basically is a form of intellectual property, and that intellectual property refers to creations of the mind. It's a general legal term, and it covers a number of areas of the law, including patents, trademarks, copyright, industrial designs, even plant breeding rights. It is sometimes used, intellectual property or IP, the term is sometimes used interchangeably with copyright, and it will be used a bit interchangeably in this session. So copyright itself protects the original expression of ideas. So as soon as some content is in a material and recorded form, it's protected, basically. The copyright for digital and hard copy, the rules and the legislation is pretty much the same. However, there are some notable exceptions, and this is what we'll talk about today. So with this copyright being free and automatic in Australia, basically as soon as something is recorded, as I've just said, it is protected, and you do not actually legally need a copyright symbol or for it to be registered for it to be protected. However, there are reasons why that's a good idea to include your little copyright symbol. But certainly in Australia, it is free and automatic. It does generally last for 70 years. There are some exceptions, some notable exceptions. For instance, well, we could go into certain types of artwork and anything published before 1955. If you are interested in those few exceptions, do look at the duration of copyright form down the bottom there. That's through Australian Copyright. The website there is there. It's basically 70 years from the author's death or the creator's death, or 70 years from publication if it's published after the death. There are some things that are actually don't ever fall out of copyright, and that would be sort of some letters or journals that haven't been published, and if they've been archived, then they remain in copyright forever and ever. So what we're sort of saying here is that the owners of copyright do have these exclusive rights to reproduce, communicate and publish their content, and allocate rights to others as well. So really, what's the point of copyright other than to make all of your lives misery? Well, it means that creative people can earn an income from creative works, and that is an incentive to keep creating creative works down the track. And this is sort of the idea behind copyright, all those about 200 years ago that it was set up. There are some big implications for digital use that we're going to sort of think about today. It's very easy, as you all know, it's very easy to publish online. There's a lot of content available. There's so much. It's very easy to reproduce and adapt, and a lot of material is displaced. A lot of you will find there's content up there and there's no copyright owner. It's been disassociated. And that's sort of something when you publish online and when you use content from online that we really need to think about. And we'll address some of the ways that we can protect yourselves throughout this presentation. Okay, just quickly, because I'm sure you're all aware, some of the things, just a random list of some of the things that copyright exists in. You may be surprised to know that it exists in screen captures. You may be surprised to know that it even exists in drafts and unpublished notes, as I mentioned. Okay, it does not, however, and this is the part where people get a little bit confused, it does not exist in ideas. So I've got this really great idea for this app that makes kids do their homework. Wouldn't I make a lot of money out of that? And I tell you about it, and you've got the know-how and the skills, and you go off and think, well, that's not a bad idea. You do it yourself, you create it. I've got no recourse. There's nothing I can do about that because I haven't actually created it. I haven't put it into a material form, and so therefore I'm not protected. So that's how, if it's an idea, it's not protected until you put it into a recorded and material form. Information and facts. Let's face it, you can't copyright information and facts. So the bare statistics that you can get, for instance, from the Bureau of Statistics, information, even some of the regulations and industry standards, you cannot copyright that information. You can, however, copyright the fancy table that they put it in the way that they've arranged it, how they've recorded it. So that bare information is not copyrightable. Styles and techniques, anybody can use an abstract or a realist style. The only way that they could, it's not actually copyright, but other laws such as the consumer protection laws may apply in this case. For instance, if you falsely represent yourself as something that you're not, or you mislead consumers. So for instance, you're a white person and you're doing the Indigenous dot style and you mislead consumers into thinking that you're actually an Indigenous person. So that's where other laws apply. Works mostly generated by technology. Well, a little while ago there was a case through with Telstra. They lost, and Yellow Pages and the White Pages are actually not protected by copyright because it was deemed that anything produced predominantly by a system or computer is not protected. So there you go. If you need to use the Yellow Pages or White Pages for anything, it's not protected. Names and titles is the other thing. It's considered that they're not original or substantial enough to actually warrant as a literary work and be protected by copyright. There are other ways of protecting names and titles, and that means registering it as a trademark. Okay. Just briefly, because this does come up later on, we'll mention moral rights. Anybody heard of moral rights? I think it was about 2006, the law was passed here. Basically, there's a legal obligation to attribute the owner, or the creator, I should say, not the owner, it's different, the creator of a work, of a creative work. There are, and they do actually last for as long as copyright. However, there are times when that right to be attributed and acknowledged can be waived or given up by the creator, and that includes, for example, if you work under an employer and you create a whole lot of work, then the employer actually doesn't have to attribute you. And that same goes with journalists and columnists. I worked for a publisher over East, and as a writer and editor, and we created a whole range of mass market books under one of the major mass market licenses, whose name I won't mention, and that I wasn't attributed for those books, and I'm actually quite grateful about that because of the very mass market it was. Also, sometimes it's not an infringement to not attribute when it's not reasonable. So, for instance, someone's created this fantastic logo. you're using it on banners, where on earth are you going to attribute the person? It's not reasonable to think you're going to put an attribution up there. So that's where it wouldn't be reasonable, but if you create a fantastic book cover, then it is reasonable that you'll be attributed, because there are plenty of places that can happen on the imprint page or just inside the book. And some people actually assign their moral rights to the public domain, like they actually waive their rights in that way. So they create works deliberately and give away their rights, such as in open clip art, which we'll get to. Okay, who owns the copyright? Anyone seen this image before? Nope, you have, okay. Let me just tell you a little bit about this image. Famous photographer David Slater went to the Indonesian rainforest to take photos of the macaque monkeys when one of them stole his camera and proceeded to take multiple selfies. Does anyone want to have a guess? Do you think the photographer owns the copyright, the monkey? You think the monkey owns the copyright? Okay, let's have a look. So, well, some people say David Slater does, but according to the US Copyright Office, nobody owns it. So what happened was Wikipedia made the image available under their website. They took it and they made it available in the public domain and said anybody can use it. And of course David Slater tried to sue Wikipedia. But they refused to remove the image and they said he didn't own the photo because he hadn't made a reasonable creative contribution, which is what you have to make to be able to claim copyright. Well, he argued that he'd gone to the rainforest, he'd set up the camera, chosen the right light, spent 3 days in the rainforest, paid to go all the way to Indonesia and made considerable contribution, but he lost the case. So, yeah, the US Copyright Office ruled that any works created by plants, nature or animals cannot be copyrighted, are therefore in the public domain and are free to use. And I've actually noticed on the internet there are actually a couple more cases, if you Google that, where that's actually happened as well. Yes?
The US law says it's not copyright. What about Australian law?
Well, the US law says, that's a good question, US law says it's not in copyright. The UK law, lawyers over there agree that it's most likely would be not in copyright there either, but it hasn't been tested in Australia, but it's probably fairly likely that it would be the same outcome in Australia. But it's yet to be tested.
So a judgment in America is not global?
Sorry? A judgment in...
A judgment made in America is not global, so...
A judgment made in America may not be global, but it has global implications because obviously it's available throughout the world. That's the issue. So if he wanted to, he could contest it in Australia, but it's a major office, and it's most likely will be taken as precedent if it was over here as well. So that's the difficulty. There are precedents that have been accepted, for instance, around copyright, that lawyers think here may be accepted because of something that's happened in Canada. So copyright does have a bit more of a global, can have a global sort of issue to it there, yeah. Okay, I've got a little example here. For those of you in private RTOs, and I'm sure you would have come up against this, you've copied 3 images and some text you found from the internet into your class worksheets. Is this okay? Can I have some feedback from people here? Yes? Depends. Oh, that's a great answer for copyright. This is pretty much what we say all the time.
It depends if you did it through a search engine and searched for Creative Commons type licenses.
Ah, great. So the answer was it depends if you took it from a Creative Commons style or some open license. Yes?
Does it not always also depend on whether you copy in education you can use for education as long as you acknowledge it, but you can't use it if you're going to make money out of it?
So the answer, just for the for our listeners online, was that you've said that you can use it for education as long as you don't make money out of it. Okay.
Within the classroom.
Within the classroom. Okay. Well, let's and reference it as long as you attribute or reference. Okay. So one of the things I'll say here is that just because it's available online, unfortunately, doesn't mean you can use it. And this is one of the big issues with the internet. It's there, I can use it. For schools, TAFEs, state training providers and universities, you could you may be able to use that content under the statutory licences. If you want more information, for those of you in those institutions, please do look at the Smart Copying website or go to our Vet Infonet, the department's website, and we have a fantastic module there, Copyright Doing It Right, where we talk in depth about the statutory licences and what you can and can't do and how much of it you can. RTOs are not covered by those statutory licences, private RTOs. You need to ask permission or use licensed content, and that is correct. Or use free for education content, and there is quite a bit. Just acknowledging the copyright owner does not give you permission to use it, unfortunately. You do also need, always check the website's terms and conditions to see what is allowable and what's not. And there is content, we'll get to that, that allows you to copyright for educational purposes. You're right there. It is an offence, I'll remind you, to remove a watermark or any kind of copyright information, say from an image. That's an offence under the copyright law. However, you can show an image in a classroom, from the internet in a classroom under Section 28. Most of you will be able to. We'll get to Section 28, more detail about that. If you're using a projector and you've sort of directly connected to the internet. So that in most cases would be fine. But I guess the answer really is it depends, and that was a very accurate answer. The next one, I've got a great image on Google Images. I can't find any copyright owner details. How many of you have you been in that situation? You've got this great image. Where does it come from? Yeah. Can I just use it? You tried to have a little look. What do you think? Can you just use it? No? What do you think over there? No? Yes? Reference it? Okay. Well, okay, we're getting into the topic of orphan images, and there's a lot of discussion, there has been a lot of discussion about that in copyright circles. At the moment, there's no legislation to cover that, really. There's no defence, I should say, in Australia for allowing people to use orphan works simply because they can't find a copyright owner. If you can't find a copyright owner and you can't rely on another exception, then you really either don't use it, or, I mean, you could try and make more of an effort to find the copyright owner, don't use it, or actually, I guess in the end, you'd have to make a risk assessment. Weigh up the benefit of using it versus the possible cost if the copyright owner comes and finds you, hunts you down, and takes you to court. People do want legislation to cover this issue, but it's fraught because of where do you draw the line? People could just say, oh, I couldn't find the owner, and there's a large amount of content that could suddenly be used. Yes?
So just on that one, if you do an advanced search in Google...
Advanced search in Google, yes.
And you find that image doesn't come up anymore, it's because the Google search engine will look at the metadata and find out which website it came from and whether it's copyright notice.
Right, okay.
So if you found this great image, that's
yes.
fine. Do an advanced search.
Do an advanced search.
Creative Commons for commercial use.
Yep.
If it disappears in that search, then you can't use
yep.
it.
So that's a good advice. So put it into Google Advanced, do an advanced search. If you put in the parameters of Creative Commons or free for use, and it doesn't come up again, then basically you can't use it because Google Advanced Image Search has worked out with the metadata that it's not actually covered. Good point. Asking permission. Who here has asked permission from a publisher? Yes. How has it been? Fraught, difficult, easy, straightforward? Yeah. No trouble?
I'm very accepting and happy to.
Really? That's interesting. You hear mixed results. Does it take a little while sometimes to? Yeah. Yeah. Very time consuming. You do have to allow a lot of time. No? Okay. And has it generally have they been happy to give it to you free for educational purposes or have to pay? Yep. Well, that's fantastic. It's good to know that publishers are being generous. Yes?
Perhaps query the level of permission required, because often it could be in an email form to say, yes, I give you permission to do that, but if it's just a representative of the company, do they really have the authority to represent? So, to what detail do we need to go in order to ensure that permission is actually appropriate permission?
Well, the question was, to what detail do you have to go to ensure that the person is actually qualified and able to, authorised to give that permission? What's a really good idea, and what we certainly do at the department, is that we have a clause in our request for permission that says you, and by signing this, you, I forget the exact wording, but you acknowledge that you confirm that you have the authority to give this permission, and if they sign it, then, you know, and generally, I don't know how often sort of people would be happy just to sign that and go, oh, do whatever you like with it. So I guess you have to make a reasonable effort, but I guess you can only really take it on face value when you do get that permission back. Yes.
I took a video clip from news from Channel 7 and I wanted to use in Kids for Life.
So you took a video clip of news from Channel 7, yes?
I contacted them and said, can I use this?
And you contacted them and said, can I use it? Yes.
And they virtually, for within the school, I told them
Within
the
school,
purpose of it.
yes.
And they said that's not a problem. That was a very general answer.
That's not a problem. I hope you have that recorded. Keep that email, just in case. That is a very general answer.
Yeah, and I was that I wanted it badly, but I decided to go with it.
Yes, yes, yeah. Well, keep that email, and that should back you up. Okay, so you can, some ways of getting, being able to use a substantial portion. And when I say a substantial portion, and you do need permission for a substantial portion, it doesn't necessarily mean a large part. As anything that's recognisable or an integral part of the old the resource that you're wanting to use, or an integral part of your new the resource you're creating, then if it's recognisable, you will need to get permission or find an alternative. And we'll just quickly talk now about some of the other options.
Sorry.
Yes. So, if you work at a school, a TAFE or a university, then you can rely on the statutory licences. Are you at a school or a... No, RTO. Then the statutory licences unfortunately don't apply to you. So I'm talking here in a sense that we're going past the statutory licences because we could talk about them all day and you'd all be drooling on each other's shoulders. Yeah. But in terms of substantial, a large part or an integral part, and it's difficult, but if it's recognisable as the previous resource, then I would be saying it's substantial. Yeah, it's a tricky one. I will say here that providing hyperlinks is not a copyrightable activity at this stage anyway, and I'd highly recommend use hyperlinks. I think for YouTube you can embed, they allow you to do that. Not all sites allow you to do that, so do just check the website that you're using, but certainly an easy click and kind of go URL, putting that in your content, making the students go and do the hard work or the research is a really easy way of circumventing copyright. Free material, we've already had a quick chat about that. Free licences, Creative Commons, we'll get to that in a second. You could pay for content there are many licences out there and a lot of content out there you could pay for. I'm sure a lot of your libraries would be cognisant of that. Fair dealing, which we'll talk about shortly, may not apply to you, but there are some special exceptions, which I mentioned, Section 28, and statutory licences. And again, if you want to know more about statutory licences, we're not going to talk about all that now, do go to Smart Copying or check out the Copyright Doing It Right module that we talked about. Some of the free content, and we've already had Creative Commons mentioned over here. Anyone use Creative Commons? Yes. Okay, great. I did a session yesterday and that PDF and the link, a whole lot of links to Creative Commons content will be available on the VetInfoNet website eventually. So if you do want some links, more links to free information, those of you who attended my session yesterday will have that already, but it will be available on our website. There's so much free content out there. It's a matter of just searching through it. There's a lot of rubbish there too, but there is actually some good stuff. Flickr is an image search. People's photos are uploaded. There's Pixabay as well. Free sounds for any of you doing podcasts or videos, all under Creative Commons and Wikimedia Commons. There's so much there, and I do urge you to check our the PDF, the free copyright PDF that I will make available in the PDF. OER, that's got the open education resources. We talked about that yesterday as well. A whole lot of resources under Creative Commons. Anyone heard of free digital photos? Actually, it was a lecturer that told me about this in one of my sessions. Free digital photos is this a standard stock photography sort of library, but they do make low-res images available for any purpose, as long as you attribute, and they're really strict about that. So it's low-res, small images. You want to have a really professional quality image on your resource, that's what you can use. You have to acknowledge right there and then, exactly where it is. If you want a larger image or a higher res image, then you will pay, and that's how they make their money. But it's a fantastic service. Open clip art. Who likes to use bit of clip art on their presentations? Let's face it, you know, blank screen's pretty dull. If you're into using a bit of clip art, Open Clip Art has images in the public domain. There's some really good stuff there. There's also some rubbish. Yes, question?
People might want to take that down because Microsoft
Microsoft,
is taking that down.
yes. Microsoft is a problem. Now, the image I've got up here, I've used courtesy of free digital photos, just there. But yeah, Open Clip Art is a good alternative to Microsoft. I know that they've made some changes to their... It's completely gone. Yeah. Yeah, I've heard that. Yeah. Okay, and anyone heard of, we talked about this yesterday, the Project Gutenberg? Yes. If you need large literary texts, or you just want to read a book, a classic, anything that's out of copyright is available in Project Gutenberg. About 3,500 novels or pieces of literature by memory, including, I think we talked yesterday, George Orwell, 1984, Animal Farm, Gone with the Wind, bit of light reading. And the other option that we talked about yesterday is your own original materials. That's not, well, it's copyright because you or your employer will own it, but you can do what you like with it then. And we said yesterday, if you're creating your own materials, don't forget to record somewhere that it's your own materials, because down the track, someone else will inherit your resource and they'll go, where'd this photo come from? We don't know, we better take it out. So yeah, it's always a good idea to acknowledge somewhere where this content has come from and keep it in a place that people can find it. It's nothing worse than inheriting something, and I'm sure you would all have been in that situation and you have no idea where the information comes from. All right, just quickly, we're going to talk about fair dealing, only because this will apply to most of your students. It won't necessarily apply to you, and we can also talk about memes and mashups, which we'll get to. Fair dealing is an exception in the Copyright Act that basically allows people to use, and it's around the 10% mark. There are restrictions and more information is available from copyright in this particular little fact sheet. But for research or study, criticism or review, telling the news is the other one, and for parody or satire, fair dealing doesn't cover you if you're using it for anything for commercial purposes. Yes?
Our students are very, very keen on copying photos.
Copying photos, yeah, for students, yep.
On the internet.
Yes.
They're not allowed to do it, but if you look in their drives and see the whole collection of it, no idea where they got them from, not even an idea whether they were copyrighted.
Okay, so your students like to... Okay, well, students, if they're copying content for educational purposes, then...
These are photos of singers, stars, models.
Well, yeah, like I said, if it's for educational purposes, for study or research, then, and even personal study or research, you're covered under fair dealing, particularly as a student. What they do on their private computers, well, unless they're actually out there on the school drives, and that's where for schools you do need to be sort of saying, you know, having a copyright sort of, I guess, statement in place. But certainly, unless they're using that in some way, I guess you could be considered low risk. But yeah, I wouldn't be encouraging them to clog up the school drives anyway. Yes, yes. Yes, if they're being audited, yeah. Well, I'd certainly be encouraging them not to do it, and and to be cleaning out those hard drive, those school drives. this is where, certainly for fair dealing, there is an issue about what is fair, and there's a lot of discussion about that. Again, if you're really interested in this and you think you may be able to rely on it, then I would be reading up more about this. We won't be going into too much detail. I will say most of you won't be covered by this. It doesn't cover teaching. In the US, there's the Fair Use and Teach Act, and that is covered by teaching, covered for teachers. But unfortunately, in Australia, we don't have that. We do have the statutory licences for certain institutions. So our fair dealing is quite different from the US, and that can be a bit confusing with internet material. I will just briefly touch on memes and mashups. How many of you have been using memes or mashups in their classroom? So, for instance, they're all over the internet. You've got a funny photo, and you've got some funny kind of text added to it by somebody else. Usually it's a photo of someone famous, and it's a bit of comedy, a bit of light-hearted humour. No? Well, I'll just say in terms of fair dealing, and for all of you using it, sharing those kind of images on, say, Facebook or on any of the other social media, if it's purely for parody or satire, you may be covered under fair dealing. If it's going to be used commercially, you won't be. Just go. This is my very lame attempt at a bit of a mashup. I've got this image from Flickr. A wonderful photographer captured a parrot, and I've added my own text. I really didn't do it very well. So again, like memes or mashups, they can include images and text. It can include text, like different stories and novels being sort of integrated, different scenes being put together in videos. I'm sure some of you might have seen videos that have certain, someone speaking a different, funny other script on top of it, and even audios that have been mashed together. This is really popular, certainly with students and with some teachers. Some teachers love it. There's still copyright present, so if you're creating those yourself, do try to use Creative Commons content, licensed content, and there could even be a moral rights issue there because the original copyright owner is not being acknowledged. And any of these memes that I found, I googled them and found this huge list of memes on the internet. Couldn't see a copyright owner acknowledged anywhere. So you're pretty much covered under parody or satire if that's purely what you're trying to do. But as soon as you start making something commercially available, you're not covered under fair dealing. Okay. Any questions at this stage now that we've got the any questions image up? Okay. All right, we'll get to that special exception I mentioned before. So how many of you like to show videos in the classroom? Anyone using videos? Yeah. Yep. Little clips. Where do you get your videos from? I asked this yesterday. YouTube? A lot of YouTube? Okay. So Section 28 under the Copyright Law Act does allow you to use that in a context not for profit as part of educational instruction, and you can generally stream. You cannot download is the big thing I will say about this. So you can do all sorts of things for educational purposes, not entertainment, not for lunch. You can show commercial DVs, display material through whiteboards, and as I mentioned before, stream. You can show images from the internet. You can stream YouTube and DVDs in the LMS. So as I said, you cannot download content for Section 28. You cannot communicate or perform something in the public, for the public, that's not covered, and no Bali DVDs, okay? So try to use legal content. Okay, if you are interested in format shifting or downloading something, you may be covered if you work at a school, a TAFE or a university. Unfortunately, the RTOs are not covered under that. If you're interested in 200AB, there are a whole lot of tick boxes you have to tick off, and I'd really recommend looking at either and both of those resources, those info sheets, to find out if you qualify. So, for instance, you're teaching in a remote community, there's no internet access, you need to download something. Then you may be eligible for Section 200AB. You maybe just have to look at all the options there. RTOs are not unfortunately covered. So just talking about YouTube. So just a show of hands, how many people have actually used YouTube in the classroom? Most of you? Okay. It's great, isn't it? It's a fantastic service. There's some really great stuff up there. Just let me warn you about a couple of potential issues. The YouTube terms are usually actually personal non-commercial use, despite this being a site that makes everything available and the purpose is to share. It could be argued, and I think there was a case in Canada, as I mentioned before, where the precedent was that just by clicking on and using a certain service, you could be considered to be agreeing to the terms and conditions. So we don't actually click on anything to say I do agree, but by using it you could be considered. And there's no precedent, I believe, I understand, in Australia. So there's another issue. There's so many layers, or could be so many layers of copyright in a YouTube video. So you think about it, you've got music, you've got a music video, you could have a script, you could have images, sound, the recording itself, could all be owned by different people. So that's just something to think about. The other, as I mentioned, you may be able to stream YouTube in a classroom under Section 28, and we've already discussed that. Let's just, oh, sorry, wrong one. Some of the options that you have, you could try to find Creative Commons YouTube content. They do exist. You have to do a bit of an advanced search, but they do exist. You could try some of the other websites, like the Khan Academy. They do actually have a whole range of content available. I guess you just need to use some common sense when using YouTube content, especially if you're able to under Section 28. Use some common sense. If it's got the latest Hollywood film, the latest Hollywood music, and it's produced by someone that's not the Hollywood producers, then there's a fairly good chance that they don't own the copyright to that. Yes, a question?
Yeah, that was sort of answering my question, because you might get fast scales, 68's uploaded, a
Yes.
John Cleese sales video.
John Cleese sales video, yeah. So you do have to use a fair degree of common sense, unfortunately.
Section 28. If you can reasonably assume it's a commercial product, you can.
Yes, no, that's right. You could be, that's right, you'd be infringing if it's the latest Beyonce clip playing to the music. Okay, yep. All right, who uses iTunes here? Anyone used iTunes in their, oh, resounding silence. Yes, we got an iTunes. All right, this is even more fraught. Not that I want to scare you too much, but Apple, the Apple terms are quite clearly personal non-commercial use, and to use iTunes content you would have actually had to, you will definitely have signed and agreed to the terms and conditions. We think it's believed that the iTunes terms actually do clash with Section 28. We do suggest using instead free iTunes content, free for education, music, anything purchased under Audio Network, and there are a whole range of options. It's just a very difficult and fraught area, and trying to get a straight answer out of Apple has proven quite challenging to date. So it's a difficult one. We kind of would need to say then try CDs under Section 28, but who uses CDs, you know, and that's the difficulty with using iTunes. Again, if you work under for a state training provider, a school or a university, you may be able to use iTunes and convert it under Section 200AB, okay? But RTOs, unfortunately, wouldn't be able to rely on that. Most RTOs, I should say. Yes, question?
If you purchase the CD and then download it, is that
No, for Section 28, you can actually just play it straight away. You can't download, unfortunately, under that legislation, yeah. Again, I guess in these situations, you've got to use a degree of risk assessment as well, weighing up the risks and the likelihood, you know, that, how that may pan out down the track. So, yeah, I won't say too much about that. Blogs, wikis, podcasts, and vodcasts. Anyone use podcasts? Vodcasts? No? Webcasts? Anyone use Collaborate, Moodle? Any of those? Yep. Okay. Certainly for the institutes and the schools, if you are actually copying and storing information under a statutory licence, you must, especially under Section 200AB, you must use password protection, and you must include a special statutory licence prescribed notice, which you can find out more about that on our website too. But for everyone else, I'd recommend using Creative Commons material, open education material, do link to websites instead of copying, and do not use recorded music unless you've got an APRA AMCOS licence. That's a big one. Use licensed music. There's some options there: CC Mixter and Jamendo. Okay, this very attractive photo, just to give you an indication of some of the content you can find in Flickr photos, and we're going to talk about attribution really briefly now. You see here that I've taken this image, and this is the attribution that I've included down there, and that is one of the basic rules of using Creative Commons content. Okay, who here includes an attribution or a copyright notice on their own work when you create work? What kind of copyright notice are you including? The Durac, okay, yep. Any others? Anyone put their own name on it? Yes? What do you use? Yeah, your own name, yeah, okay. All right, well, as I mentioned, it's actually not a legal requirement or necessary under copyright law to include a copyright notice. However, it's a really good idea and it's good practice because it's a good visual reminder that basically that you do own. It's telling people giving them information about who owns it, who they can go to, or hopefully go to get information about how they can reuse it as well. So it's also, if you're working for a state training provider, school, university, you do need to include that kind of information, because when you're surveyed down the track, if there's no copyright notice or if there's no information about who's owning it, who's owned it, your material, your own photos even, then you'll actually be charged for it. And that's generally how the Copyright Agency works. They can't find that information, charge it to your institute. Okay. So really we're sort of saying copyright, XYZ Institute, this can be really simple. You can include information about who to contact, and if it's appropriate, acknowledge who wrote it. Often that's not in an institute or an organisation. So third party, you've written to Penguin Books and you've got permission to use, or Pearson Education, you've got permission to use a whole bunch of text and a couple of images. Generally, they will tell you, third parties can tell you what information they want. They may want a really special kind of copyright notice, attribution, and they often tell you where to put it, and sometimes they don't, they make it really vague. So the general rule of thumb is make it clear, make it legible. It can be small, as I've made it here. Place it next to the work or in the footer. And the same goes for videos. You generally would have a screen afterwards with some information, but if you run out of room now, you are allowed to include a link which has all of the credits. That's allowed in last resort. Certainly with sound recordings, I don't know that anyone here uses podcasts or creates podcasts. Nope. If you do, when you do, I know that some schools are doing that now with students. You do need to make that the name of the artist available as like a radio broadcast, and you can actually put those credit notices right next to where the podcast is stored. Again, okay, say you've got a PowerPoint presentation, you haven't got a lot of room, you've got all these images. As a very last resort, you are actually allowed to, and we mentioned this yesterday, use a referencing system and have your credits at the beginning or have your credits at the end. As long as there's some way of showing people that there isn't a copyright notice somewhere else, so numbering or some system letting them know that it is under copyright. Okay, now we get to the free beer part. Just joking. Later. So this is just an example of me having found a fantastic cartoonist. He's got really great content, and he's deliberately chosen to make this available online and under, he's called himself Hiking Artist on Flickr and also on his own personal website. I found this on his own personal website. And he's got a huge range of content and cartoons with quite a big social commentary. Okay, now we get to the fun part, social media. Who here uses social media? What are the advantages of using social media in the classroom? Anyone want to throw a few comments at me? Why do you use it? How do you use it? Do you use it in the classroom is what I should have asked. No. Anybody use it in the classroom? Any aspect? Yes?
Well, mostly for protection, security, safety purposes.
Ah, so mostly for protection, security and safety purposes, right, okay. Okay, well, there's a lot of arguments for using it, certainly for businesses. Any of the RTOs here or institutes use it for that? Does their institution or organisation use it for advertising purposes? Yeah. Okay, well, there are huge, as I said, there are huge advantages. It can, increase your exposure, huge reach and audience. It's relatively easy to use. It can add a human sort of element and sort of gain loyalty. And it can actually increase, according to some experts, increase student participation and collaboration. It can also be immensely distracting, but we'll get into that. I just want to warn you about a couple of copyright issues, and some of you will be already aware of this. So the couple of issues include issues of privacy. I'm sure most of you will be aware that you sign up, and you do actually, when you sign up, you give them a non-exclusive, transferable, sub-licensable, royalty-free worldwide license. And that's pretty much the standard contract for most of these social media services. And that means they can basically do what they like with your content. There've been some cases recently in the media. Anyone heard about the SBS journalist who made some inappropriate tweets for Anzac Day? He's lost his job. He's now suing SBS. And then just after that, there was another SBS journalist who posted quite a critical article of SBS on her, I don't know if it was Facebook, might have been Facebook page, and she was fired as well. And there was also, in the mass market media, there was that woman who actually lost her job, her daycare job, before she even started because she posted on Facebook that she thought children were a bit annoying, which is not a wise thing to post just before you start a childcare job. So there are kind of privacy, and there is a huge range of issues there. But in terms of the copyright risks, what you post up on, for instance, Facebook, remains viewable even if you take down your content, if it's been reposted or viewed, and in some cases it may have been cached, say in Instagram, or if any third party has copied it, then they can continue to use it as they please. So basically when you upload your content, you're giving them, these sites, a free rein, free license to do what they like. To make it worse, a lot of these sites actually then also have in their terms and conditions the onus that you will be responsible, legally responsible, if you repost something that infringes copyright. So not only are they allowing you to do it, but they're basically saying, well, if anything goes down, we're not responsible legally. So it's just worth thinking about that when you're posting and reposting. So what can we do about this? I'm painting a really doom and gloom picture here. There's some really simple things and simple ways of trying to protect yourself. You can include, so if you're using websites or any information on the websites, as we said before, include a copyright statement and make sure that students and teachers are aware of how they use content and how they could be breaking the law around content, including a warranty to indemnify your agency or your organisation. Really simple thing, using the copyright notice. Again, not required, but it could actually just, it's a great visual reminder. It's like having security bars on your window. They'll get through if they really want to, you know, they really can if the bottom window, especially if you just kick it in, but it's an extra visual reminder and it's an extra deterrent. Use social media with caution. So if you do have to upload images or content, make sure first of all it's cleared, but second of all, use watermarks if it's valuable IP, valuable images, or use a low resolution is another option. To track your works, people are going to great extremes, and for some people I think it's become a bit of a business. Produce a whole lot of photos and then certainly in the US, I've heard of cases where people spend their time just producing rather mediocre photos and then tracking people down and suing them and getting the money. So you can actually try it. There's an app called Google Goggles. You can try to find information about your images there. And I know photographers that do actually use that. Or Mark Monitor, you do pay a company to track it down for you. Or you could simply go into Google or your search engine, type it in, and that's one way of tracking down information. Okay, getting into really overall managing copyright risks. Do most of your organisations here have a copyright risk management? Everybody? Yes? No? Maybe? You should have something in place. So you do need to implement those policies and procedures, making sure everybody's aware of it. When you're downloading or looking for content for your resources, make sure that you check the terms and conditions. Get permission or use licensed material is really what we're saying here. And do definitely record copyright permissions, especially STPs, TAFE schools, universities. You have to record that anyway legally. But for RTOs, it's always a good idea to keep that information accessible, especially down the track when somebody wants to reuse your resource. Any questions? We've galloped through that. It's a lot of information. Any questions? Yes?
I have a question about the transferability of permissions. So if,
yes, transferability of permissions, yep.
As STPs, we share information, we share our content within the sector.
Yes.
If you're receiving material from another STP, for example, and that STP has been given permission to use that content, is the transferability of the position specific only to that originating agency?
So the question here, just for our online participants, is in terms of transferring content and permissions having been given to one STP, is it transferable to the other STP? Unfortunately, it's a depends answer. It will depend on the contract that you have or the permission that you have with that the copyright owner, and it would have to be considered on a case-by-case basis as to whether you're actually whether you've covered for that. It depends if it actually says on the permission, I allow this particular STP, specific STP to use it, or whether the permission is we allow you to use this content for this product or this resource. And that's where you've got to be a bit clever about the permissions that you're getting people to sign, or your contracts, and really word them in a clever way. We do have information on our Copyright Doing It Right module, the free online module at VetInfoNet, which I mentioned before. Just put it at Copyright Doing It Right, put that into our VetInfo thing about the type of contracts and things to look out for in permissions and contracts. We have some very basic samples, but I would recommend getting legal advice in terms of having a really great standard contract for and permissions statement for handing over permission. Yeah. Question?
We provide iLearning through our campus.
iLearning for your e-learning, or
courses.
right?
So students access that through Janice. Now they all need a password to get there.
Right. Yes.
They can't really copy it. It sits there.
Yes.
But if they use copyright and items and they've acknowledged it, because we are obliged to
Yes.
acknowledge the copyright, are there any other precautions? Because I think you said it's got to
Well,
be kept separate.
sorry. So the question is, they're using yep. The students who.
The teachers make up their own worksheets, their own
Yes, the teachers.
teaching information that they write themselves, or
Yes.
they refer
So
to
the teachers
textbooks.
create the
But-
worksheets.
but-
Yep.
But if we use anything that that is copyright, we acknowledge that copyright. That's always
So
done.
yes,
But
you always acknowledge.
is it
Yes.
okay just for it to have it there, or do we need to take more? Do we need
So
to do more in
it-
iLearning?
So I'm assuming, though, I'm not completely.
Well, let's take,
That's
for example,
yes,
history.
example.
So you
So,
wrote
but what I'm trying to understand is with Janison. Sorry to talk over you.
Oh,
So,
sorry,
with Janison, this is a license.
Oh, yeah,
Yes, that's right. Yeah.
That's
Yes.
the program we're
That's the
using.
program you're using.
Yeah,
Okay.
Most use Moodle, we use Dennis.
Yes. Okay. Yeah.
Yeah,
And where are you getting that copyright content from?
So we may, for history, you may take a photo
From where?
from you might have found it on the internet. a
On the
photo.
internet. Yes.
So you acknowledge it, or
Yes,
even
you
if,
acknowledge it, yep.
Yeah. So that type of thing.
Yes.
That,
But
is it okay just to have it there, or do we need to take more?
well, the point, I guess, is that the question is it okay just to have it there? The point is that you would need to try to use content that is actually you've found through Creative Commons or an open education licence. As an RTO,
We're a school.
oh, you're a school. Well, as a school, you are covered under the statutory licence 5B, and you can, in many cases, just use content from the internet. So that's the advantage that you have being in a school, a state training provider, or a university.
Even if it's
Online, yes, that's right. But do check the Smart Copying website for what you how much you can actually use under the Part 5B statutory education licence. Do look that up. We can't talk about that here today, but yes, there are limits as to how much you can use depending on the type of content. So as a school, yes, you're fine. Any other questions? Well, thank you. Thank you very much. I will be here if you want to ask any questions. I'll be here for the next 5 to 10 minutes. But thank you very much for attending, and I hope that's been informative. If you do think of anything afterwards and you want to contact me, please feel free through the IP unit at dtw.wa.gov.au. Okay, thanks very much for coming.
Authorised by the Government of